That's you, Emily.
Okay, welcome back to, ladies and gentlemen. Woo! Guys, we're gonna start again. So we've had a very brief break. We're going to pivot to unpaid leave to H 461. Is that right?
Yes.
H 461. And we have had a great walkthrough of the bill with our legislative counsel, Sophie Zadatny. And we are now going to talk about, we're now going to flush it out with concerns and suggestions with a number of advocates and lived experience people. And I think we're going to begin with David Martin. Is that right? Is JP? Here. I think we're going to start with David Martin, and who has been waiting patiently. David, we apologize. We had to finish our financial priorities for the Senate Appropriations Committee. So that was must-do work that that meant that we will continue our unpaid leave discussion well beyond this one meeting today. And we're going to begin with you because you've waited so David, welcome.
No apology necessary, Senator. Thank you for the opportunity.
Well, you're not going to make yourself visible. You're on the phone. Is that right?
That is correct, ma'am.
Great. So, David, you're speaking to a committee of 5, and we're going to introduce ourselves and just quickly, and for all the other advocates that are in the room. So, Thomas, you want to begin?
Hi, David. I'm Tom Chittenden. I represent the southeast quadrants of Chittenden County with
Hey, Sharon.
Allison Clarkson, Windsor County District.
Randy Brock, Franklin County in Northern Grand Isle.
And good morning, Dave Weeks, representing Rutland County.
Great. So, David, it's wonderful to have you. Thank you for joining us from California. And would you be kind enough to weigh in on this bill and how it affects you and what your suggestions are?
Absolutely, and thank you again for the opportunity. And the first thing I'd like to do is apologize for the state of our written testimony. As you noted, Senator, I was traveling to the West Coast, and with all the number of aviation incidents that we've encountered over the past month or so, my colleagues and I are stretched pretty thin. So I appreciate your patience and understanding with the current state of our written testimony. With that, I'm not sure if you'd like me to go through and read my written testimony, or if you'd just like to ask some questions regarding the provisions that we suggested be included in H 461 to ensure that cabin crew, pilots who we represent, and flight attendants who are represented mostly by the Association of Flight Attendants, CWA, can make ourselves, can avail ourselves to the benefits of the unpaid leave program.
So why don't you, your letter is online. I appreciate that. And I'm not sure we've all read it. So if you'd be kind enough to give us the highlights of that, and then we can discuss it. At the moment, pilots are not included in unpaid leave.
My understanding is that language was no, you're correct, Senator. We are not. And the reason for that is within H 461, it includes an hours accrual formula. So a worker accrues 1 hour for every 30 hours that the worker works. Pilots and flight attendants' hours are calculated in a very unique way. Under that hours accrual formula, it's extremely unlikely that we would be able to avail ourselves of any of the benefits that are included in H 461. The reason being is that pilots' hours are calculated only for the hours we are in flight. So when the door closes to the time the door opens is the easiest way to explain it. So all the times, sit times in airports, layovers, some that can be 2 days if you're flying super long haul flights to Australia, or even long haul flights to the EU, those hours aren't counted per se. So when people see that, a flight attendant or pilot works 70 hours to 100 hours maybe a month, That's people kind of scratch their heads and say, well, why is that? Well, it's just that's the way our hours are calculated contractually. So
they're not the hours you're paid, because you're paid for all the hours that you're waiting as well, right?
unfortunately, no. We are only paid for the hours that we are in flight. So from the time the door closes, when you push back from the gate, until the time the door opens when you're at the gate of your arrival city. So all the other hours are just part of decades of trying to figure out how you pay cabin crew, if that makes sense. So there's also federal regulations as well via the FAA that preclude pilots from flying more than 1,000 hours in a calendar year. So with that, if you just kind of do the back of the cocktail napkin math, if you take 40 times, just call it 50 weeks, you get 2 weeks vacation. The average worker, full-time worker, will work, 2,000 hours, where we're capped by federal regulation and needed federal regulation. Those regulations are in place to ensure the safety of our members as well as passengers, and to mitigate fatigue problems that science has shown us over the decades as well.
So David, this is an association that is national, or is this just a Vermont association?
No, I'm the senior legislative representative for the Airline Pilots Association International. We represent approximately 80,000 commercial pilots in the US and Canada, including in every state of the United States.
Got it. Okay, thank you. That helps set our table. You only do pilots and you're not cabin crew, correct?
I'm sorry, I heard that we only do pilots, and I'm sorry, what was the last part, Senator?
You don't represent cabin crew, because you've referred to cabin crew, but you don't represent them. Is that right?
Correct.
Yeah, and but they have, is it a similar concern for the cabin crew that they're also only, that their work time is only considered when they're in the air?
It is. Prior to my 16 years here at the Airline Pilots Association, I did work for the Association of Flight Attendants, CWA, for about 7 years, and focused on our flight attendant members there as well. So yes, it's a very similar hours calculation. If memory serves, I don't believe there's a federal regulation in place to the point of like ours, where we're capped at 1,000. However, the hours are calculated about the same way, and it would be highly unlikely that a cabin crew or flight attendant could achieve or avail themselves of the benefits under this current hours accrual formula in H461.
So, high level, land us here. Do you have language that you have? I apologize because I have not seen your memo, and I'm
Yes,
sure
no.
I have my.
Sorry. Yes, in the written. Sorry, go ahead, ma'am.
I think we'd like to know, and maybe Thomas has it pulled up. A couple of you may have it pulled up. What is your ask, and do you have language that you'd like us to consider?
Yes, Senator. There's language included in the written testimony we submitted where we make some slight tweaks to the definition of employer and employee in 4 and 5. The good news here is that this is not an uncommon issue, both at the federal and state level. When the federal government passed their unpaid FMLA in '93, I want to say it was, there was a similar hours accrual problem for pilots and flight attendants. And we worked with the Congress and the Department of Labor to come up with CFR 29 CFR 825.801, which basically just institutes an hours accrual formula that more accurately represents the way in which pilot and flight attendant hours are calculated, so that we are able to achieve the same level of benefits as other workers.
So thank you, David. We now have your language in front of us. Thank you, Heidi. And our legislative council also has the language in front of us. And I assume you tried to rectify this in other states. How many states have you rectified this with?
Yes, we've been successful in several other states. The most recent examples would be Minnesota last year and Michigan this year, using the same fix, the reference to 29 CFR 825.801.
Got it. Any questions, Tom?
This makes perfect sense to me. I have a brother-in-law that flies for United, so I definitely support the language, and it makes sense to give this carve out for you.
Yeah.
Oh, we appreciate it.
Yeah, it seems to make sense, and it's just frustrating that yes, not everybody gets caught. Any questions, Randy and David? Anything from the patient?
Yeah.
Sophie. So our legislative council is just seeing this. You may have seen it earlier. No, we're just seeing it. Any questions, Sophie, that you have for David?
I guess the one question I have is, how many of your members would this apply to? I mean, I assume it would apply to those whose base is in Vermont.
Yes, that's the way that we've gone about it. That's the most efficient way to figure out who would actually be covered under state leave laws. So that's kind of where we land, regardless of the state that we're working to ensure that our members can avail themselves to the same benefits.
Right, where you land, haha. So, question.
I didn't even mean that.
Yeah, I know. Yeah, Steve Foster. So, how many pilots do you represent in Vermont?
Our best estimate is a little bit north of 100.
Great, thank you. Anything else to add, JP or Sophie? Any other questions? Thank you, David. I think that's very helpful. Always want to catch those who are not included. So, who do you suggest we speak to for the cabin crowd? It sounds like the cabin crew also need to be included. Would this language cover them as well?
I can get back to you on this, but I feel very strongly that our suggested fix would actually capture flight attendants as well. It's the same reference. If you go back to the definitions used in 29 CFR 825.801, it talks about cabin crew, and cabin crew is a common term used to describe pilots and flight attendants. But if you do want to speak to somebody, CWA represents AFA, the Association of Flight Attendants, is part of CWA. IAM, the International Association of Machinists, represents the South. They represent some flight attendants, and then TWU, the Transport Workers Union, they represent the Southwest flight attendants.
Yeah, well, we're trying to cover Vermonters, so not sure where. So thank you. I think that's helpful. If you think this language would cover the cabin crews based in Vermont, I think that's good to know. So thank you, David. That was very helpful.
No, thank you. We appreciate the opportunity. If I could take a point of personal privilege, I'd like to thank Ms. Parker for all of her work and her help in making sure that the committee members were able to hear this and ask questions. So thank you to Heidi.
Well, thank you for.
We've
been talking about the pillars to certain aspects of our economy. She is the pillar for the functionality of this committee. So thank you for acknowledging that.
Thank you very much. I appreciate your all's consideration.
Yeah, David, you're patient and clearly enjoy the West Coast.
I will. Thank you.
Johanna, we have Johanna or Carrie next. Johanna?
Do you want to go? No, go ahead.
Johanna, welcome.
Hi. First of all, it's a pleasure to introduce myself to this committee. This is the first time that I've had the opportunity to come in and testify this session. My name is Johanna Grafenreid. I'm the Public Policy Manager for Vermont Businesses for Social Responsibility. I have a piece of written testimony that I'm going to provide for you all, and I'll make sure to email it to the committee assistant afterwards, and then happy to answer questions. First of all, thank you again for the opportunity to testify in support of House Bill 461, an act relating to expanding employee access to unpaid leave. I represent nearly 600 members of Vermont Businesses for Social Responsibility. Our members include small and large businesses, ranging across all economic sectors in Vermont. For years, VDSR has supported comprehensive universal paid family and medical leave for all Vermonters, and H 461 is a pragmatic step to equitably expanding paid family and medical leave and we certainly support the passage of this bill into law. There are several aspects of H 461 which I want to address in my testimony today. The first is the importance of expanding paid family and medical leave, in this case, unpaid leave, to include LGBTQIA employees in Vermont. 12 states have expanded their paid family and medical leave programs to better include LGBTQIA employees and their families, including Connecticut, Maine, New York, and Massachusetts. These states have expanded their paid family medical leave programs to cover LGBTQIA individuals, even if these couples are not legally married, with 19,000 employees identifying as LGBTQIA in Vermont as of 2020, according to the Williams Institute at
Sorry, how
UCLA.
many did you say?
19,000. The proposed coverage expansion in H 461 is a crucial step towards addressing paid family medical needs of working LGBTQIA Vermonters, their children, their family members, and their partners. The second item in the bill, which BDSR strongly supports the inclusion of, is miscarriage being explicitly named as a medical event covered by this unpaid family and medical leave proposal. I can get a little further into that into my written testimony, but just want to say that we appreciate that being included explicitly in the bill, as often that can slip through the cracks as something that's covered as a health event with family and medical leave due to the nature of it. You don't always have to be hospitalized. It doesn't always require medication. Therefore, even though it's a significant health event, it doesn't always get covered. So it's important that we talk about it in this bill. Similarly, while some instances it might be necessary for folks to stay overnight, for example, it's not always necessary in miscarriage. So that's part of why it's really important that we explicitly talk about miscarriage as a health event, just like we do with other pregnancy-related issues.
Sorry, keep going.
Lastly, BBSR strongly supports the expansion of especially our paid family and medical leave policy, but again, unpaid in this instance, to include survivors of intimate partner violence, sexual assault, and stalking, aka safe leave in this bill. According to the Women's Bureau at the U.S. Department of Labor, as of April of 2024, 6 of the 13 state paid family and medical leave laws permit employees to take leave to address the needs of survivors of domestic violence, sexual assault, or stalking. So again, 6 of the 13 states that have a paid family medical leave program include this safe leave. It's also important to note that of those 6 states, Maine is one. So when we're looking at our colleagues who are in similarly situated states. Often survivors of stalking and violence need time to seek medical or mental health care, relocating to a safer home, going to court, or finding support services. And according to national survey data, 15.9 million US women, approximately 12.7%, and 6.7 million US men, a little over 5%, have missed at least one day of work due to intimate partner violence or their effect on their lifetimes. Ensuring that this time is paid would be ideal, but we of course support this unpaid expansion. I also want to leave you all with some information about the benefits to employers and the economy when employees are covered under a robust paid family and medical leave policy. Caregiving is the bedrock of Vermont's economy and significantly impacts a business's bottom line. Employees often face a tough choice of leaving their job for caregiving duties and medical needs, while employers bear the high financial and cultural costs associated with employee turnover. This economic dynamic has a pronounced impact on gender equity, as the majority of those leaving their careers to provide care are women. In Vermont, there's a notable 6% labor force participation gap between men and women, and expanding our paid family and medical leave policy will only aid in addressing that gender gap in our workforce and ultimately expand the number of employees available for hire during our state's workforce shortage that we're facing. A lack of paid safe leave also harms businesses and the economy because of reduced productivity and the cost of increased turnover. The National Institute of Health published a 2017 study estimating that the American economy loses approximately $137.8 billion in 2017 alone in short-term productivity loss due to gender-based violence and harassment. Providing employees and their families the time that they need to seek medical and legal resources after instances of violence and stalking promotes job security and Vermont's economy. Additionally, Vermont has an aging population, and workers need resources to be able to care for themselves and aging Vermonters. Right now, more than 1 in 4 Vermont workers are 55 and older, and within the next 20 years, the portion of Vermont's population age 65 and older is expected to grow by more than a quarter, as you all know. Family caregivers already are spending an average of a quarter of their income on caregiving activities. However, a universal paid leave program, we would love to see a full expansion of the program, would add about 13,000 family caregivers to Vermont's workforce by 2030, a telling figure given Vermont's current workforce shortage. Vermont businesses for social responsibility for the reasons I've listed in this testimony, as well as countless ethical and economic arguments in favor of a larger, robust universal paid and family medical leave program, supports the passage of H 461 into law. We hope that the legislature will continue to expand this crucial program for all working Vermonters and their families. And this bill is a thoughtful and important next step in making paid family and medical leave policy more equitable, fair, and inclusive. I want to thank you all for your time and for the opportunity to speak on behalf of UVSR and our members on this.
Thank you. Thank you very much. Much appreciated. Any questions from our committee? If you would be kind enough to get us your testimony, that would be terrific.
Yeah, happy to.
That is great. I just love to know who tracks, who takes advantage of this federal program at the moment.
So right now it's a state-based program. We have a voluntary state program here in Vermont.
So but it is a federal program, unpaid family leave.
We have a federal program
That
that
we
is
have
for
built
50 employers and over, for employers that have over 50 FTE. But we have one that we built on here in Vermont that includes smaller businesses.
So who tracks who takes advantage, who uses it?
So we've been trying to figure that out. I will say that first of all, that program was only opened up for voluntary participation really recently within the last year. And so we've been trying to gather more data about who is actively participating in the program, but it's pretty shielded by privacy laws. So
Yeah, no, this is a challenge because it would be, to go to Randy's always point, which is who we need to, it's a key piece, I think, as we try and move to appreciate who's actually in such need they're willing to take unpaid family.
Mhm.
So it strikes me that I don't know how we get it, but it would be great to be able to get some of that.
I agree. And I think it would be great if the administration could come in and speak to the Hartford, the insurance program that's been contracted by the state, to see if we can get a little bit more information there. I will say safe leave is not included, as far as I understand it, in the paid leave program, Harry. And so this would be just the initial expansion of safe leave specifically for unpaid leave. So just highlighting how that's currently working. It's not that we're adding an unpaid leave section. It's that it's not covered.
Oh, no, I'm clear on that. We're clear on that. I'm just, trying to build a case, but it's very hard to do given HIPAA, and it would probably have to be with employees who trusted their employers and employers' HR departments who were clear on the purpose of the leave. So I don't know how we do that, but there are enough brains in this room, around the room, that we can maybe begin to figure that out. And okay, great. Thank you. Thank you very much.
Thank you so much. Please don't hesitate to reach out with any questions. And again,
It's
wonderful
lovely to have you
meet all.
here.
Thank you so
It's
much.
great. This is your first time.
Yes, this session, yeah. So thank you all so much for all the hard work you're doing. Let's reach out. And I'll make sure that,
Thank you for your work with BDSR, which we are very appreciative of. Gareth, come join us.
Carrie Brown, Executive Director of Vermont Commission on Women. There's other people who have a higher priority than me. I think you know
And
what I'm going to say.
you can come back.
And I can come back and I will send you written testimony, but I will answer your question that you just asked about how we don't think people are taking unpaid leave. We rely on survey data for that. The Vermont Department of Labor has in the past done surveys. I don't think they've done anything recently, but there are folks who do it on a nationwide level. So I can do what I can find for current, but we're not going to get exact numbers.
No, I realize that. I just think it's, as we discuss leave, it's a key piece of sort of without shooting in the dark.
Yeah.
Yeah. I mean, we know anecdotally, just because the amount of time we've spent on paid leave in this building is just huge. So many of us are pretty clear on that. Anyway, thank you. So I apologize, but we did have a priority. So Charlie is here. I know she has a big recommendation, and I know Megan would like to speak, but I also know Carrie and Megan could come back. So I think if it's okay with everybody, we'll have Charlie come and join us. You have a specific recommendation and I know Sophie's here now so that we can discuss that more fully, because I think there are some solutions to what you are raising. So if you would be kind enough to join us, welcome.
Perfect. Well, thank you so much for having me. I'm Charlie Glisserman. I'm the policy director of Vermont Network Against Domestic Sexual Violence. Chair Clarkson, was there something?
No, you heard us all introduce so.
Yeah.
And I think you know us all. Maybe you haven't met David yet,
I
but
don't know if we have the opportunity.
Either home and welfare or education.
Perfect. Well, it's wonderful to reconnect here. I mean, this is the first time I have been before this committee in this role. Very briefly, the Vermont Network is our state's leading voice on domestic and sexual violence. Our members are 15 independent nonprofits that provide direct services to survivors of violence and their families in Vermont communities, and also provide prevention programming. And together they serve every town in Vermont. We are very proud to support H 461. I'm going to speak very specifically to the safe leave portion because I know you folks are tight on time. Survivors deserve time to heal and access support and safety for themselves and their children without fear of losing their jobs. And so we think that 12 weeks of unpaid safe leave is an important step forward towards getting survivors what they need to access important services like safety planning, medical care, and the criminal legal system. One story from Mosaic, our member organization serving survivors of sexual violence in Washington County, illustrates the importance of these protections. They shared with me that a 12-year-old Emma, whose name has been changed, told a trusted adult that she had experienced abuse. Emma and her family worked hard to heal and navigate Vermont's criminal legal system. And Emma's mom took time off work to take her to a sexual assault nurse examination, multiple visits to forensic interviews, meetings with advocates, lawyers, and the state's attorneys, court hearings, therapy, and much more. Emma's mom had to take additional time off to field phone calls and meet individually with therapists, attorneys, and Emma's school. And she did all of this while trying to support Emma through this process, as well as finding the support that she needed as a parent. And so I think the most important takeaway here from this example is that after people experience the trauma of abuse, survivors and their caregivers should be able to get the support they need without risking their employment. So at the request of Chair Clarkson, I did share several small changes to the bill with Sophie for consideration. I can provide a very brief summary.
why don't you do a brief summary, because we'll have Sophie come back and walk through them, because I think some of them we may have some answers to, and some may be great additions. So,
Okay, perfect.
Great.
So I will just note kind of two of the kind of buckets of edits that we proposed for consideration. So as passed by the House, the bill references the criminal definitions of domestic abuse, sexual assault, and stalking. We would recommend referencing the civil definitions used by survivors when they are requesting civil protection orders, like relief from abuse orders, or sometimes heard of as restraining orders. These definitions better capture the scope of abuse. And so we think that as survivors are, trying to get the relief for themselves and their families, that it should encompass the full scope of abusive behaviors that we recognize in our civil laws. Secondly, currently victims of crime and abuse can access unpaid leave to attend court hearings. We have an existing statute that provides that unpaid court leave protection. And so currently the bill has language in the safe leave definition for unpaid leave to attend court hearings for a sexual assault or stalking protection order. We would just suggest removing that language and keeping those provisions within our existing court leave statute. Those are the suggestions that I would love to highlight for you folks today. I would be happy to answer any questions or provide any other details, and I will be happy to submit written testimony as well.
So thank you. If you would submit your written testimony, that would be great. And I think when we schedule this again, probably next week, similar time.
Okay.
Because we have, Sophie had done some thinking about it, and we will come back to it if that's okay. Is that okay for everybody? Because we are, as we move. Charlie, thank you for getting that on the table. Much appreciated.
Thank you.
And thank you to David for his new language. This is all helpful as this bill evolves.
Okay, perfect.
Thank you.
And thank you for taking the time for the work on this important bill.
Yeah, it is an important bill. Thank you very much. Great. So I think we are going to reschedule unpaid, and we'll have Megan and Carrie and anybody else who needs to testify or wants to testify on this. probably next Wednesday is when we'll probably take it up again. So we're going to shift now to cannabis, and welcome in all the cannabis advocates that are in the hall. And it's a whole shift.
I know.
Thank you for coming
Of
down.
course, thank you for your time.
Yeah, so and let's make it. And that'd be great. And then we'll have that for Wednesday. Wow. So, I will be in touch with Melissa. I've already done it.
Well, I just did, you
Yeah,
got
we're gonna get it. And you're right, the municipal assistance money should be from the PTE, it should be on it. That was.
2 weeks ago when they were worried about it, I said, "What about it? I can plan for."
Yeah, no,
That's kind of it's-
Yeah.
No.
I was like, but in all this, to only have one thing that we really, right? We all screwed up, and there we are. Okay, yeah, it's all good. We caught it and it's good. Okay. Whoa, welcome everybody.
Thank you.
Actually,
I'll shut down and then there's two over there.
hi, is Michelle really? Okay, great. Great, David, Jeffrey, there's a seat back here. David, there's a seat
Okay.
here as our council.
Sam, hello.
Okay, welcome.
No.
You can sit.
It counts as
Our other council, we have so many councils in this room, it's just astonishing. We apologize. Thank you very much for your patience. We had as our top priority today, getting our appropriations priorities identified and to the appropriations committee. So we apologize, but that was an important priority. We had to pivot to it. So we are now going to shift gears altogether and shake, rattle, and roll with our cannabis bill, which has come to us from the House and is whatever the hell, H321. So we have a room full of great cannabis advocates, and it's good to have you all here. We haven't seen you for a whole year. So, Pepper,
Yes.
would you be kind enough to lead us off? We welcome our chair of the Cannabis Control Board, James Pepper, and we will launch with you and your comment and Gabe's. I know you were sort of a theme.
Right.
I don't know if you want to do it as a team or if you just
If
want
that's
to.
all right with the chair, I will invite my general counsel up.
Great, sounds good.
You're good.
Um,
Your person.
terrific, thank you.
Okay.
So, we walked through this bill just to remind committee, I know our heads have to move, from one thing to another. We had the walkthrough with Michelle Childs last week, I believe, or the week before. And so now we're going to hear from board and from other advocates about what's supporting either what's in the bill or talking about what may not be in the bill yet. So welcome and
Thank you.
floor is yours.
Thank you. So for the record, James Pepper, Chair of the Cannabis Control Board, and joined by my general counsel. I'm Gabe Gilman, general counsel to the Cannabis Control. So H321, relatively uneventful bill. I'd say that the vote out of committee was 10-0-1. It was unanimous on voice vote on the floor. It also stopped by Ways and Means and Appropriations, also just unanimous. So as you can imagine, an issue that cannabis, which is usually controversial, being unanimous, there's not a lot in there that should surprise you. Most of it are correcting issues that we've seen, kind of fine tuning the market from the problems that are kind of filtered up to the board, just from kind of facts on the grounds. So everything but that one section are things that the board has requested. And that one section is kind of extending the employee ID cards to a 2-year option and the product registration to a 2-year option. However, we don't have any problem with that. We can administer that with very little problem. I reviewed the testimony from when you did the walkthrough with Michelle and the sponsors, and I heard you had the questions around the kind of retail moratorium and retail siting. the temporary permit to oversee these kind of sudden closures of businesses, or bankruptcy or divorce or death, or kind of something that was unexpected. I heard some kind of questions about background checks and then also the compliance attorney position. So what I think makes the most sense for me is to kind of let Gabe talk about those issues and anything else that you'd like to speak to, any other questions that come up. And then I'm happy to kind of talk about, well, you're probably going to get requests from people in the room for new things. And, you know, they've shared some of those with me. So I do have, you know, thoughts
You
about
have
those.
some thoughts in those, and the question I have for you is, would you like to wait until they've testified, or do you want to wait? I think maybe you shouldn't color it,
Okay.
and maybe you
yes.
should respond.
Okay.
That is sort of my
that sounds
initial
great.
thought.
Yes.
Okay, great.
There's just one last thing in my kind of introductory remarks. We're in the middle of an advertising lawsuit, over the kind of constitutionality of the cannabis advertising laws. That is probably on a 6 to 8 month time frame before it's ready for trial. And then however that gets decided will likely be appealed one or the other. So advertising, while it's certainly an important issue, is probably not changing the advertising laws midstream. I don't know how that impacts the case, but just wanted to let you know that is an ongoing kind of testing the constitutionality of our advertising laws is an ongoing process right now. And then we've also drafted 3 legislative reports. 2 of them were at the request of this committee. So those I can just post to the website, and I think some people here will want to testify about those as well. But with that,
And just remind us while we're all listening, the 3 reports, remind us were,
yes, one was about the medical cannabis program,
right.
just how to kind of do improvements there, improve patient access, improve kind of education for consumers and patients. And then one was about outdoor siting, outdoor cultivation siting. Last year, there was a kind of new setback that was introduced for, between kind of property lines for outdoor cultivators, which didn't exist prior. And you asked us to kind of evaluate the impact of that law. And then the last one was about how much of the cannabis excise tax should be dedicated to both the cannabis industry itself and do economic development for cannabis businesses, but then should a portion of it be used for community reinvestment more broadly for the people that have been harmed by cannabis prohibition, but didn't want to get a cannabis license.
And that will come into play with some of our witnesses
I believe so, yes.
today or in
Yes, yeah, we had a study committee that included the Land Access Opportunity Board, and Gene's here with us today. Okay, so if that plan sounds okay, then Dave, I think the first thing was the retail moratorium sightings in section 4.
So, thank you. The section 4 is the result of sort of the compromise reached in or kind of collaborative plan reached in the House side. There was a proposal there, as almost everyone is aware, a lot of concern about the overconcentration of cannabis establishments in certain municipalities that have opted in. That was sort of a predicted consequence of the opt-in system. And what everyone knew was that they had a large metropolitan area like Burlington, and some communities in the metropolitan area opted in and others didn't. The metropolitan demand would all funnel into the opt-in. That coincided with a legislative debate wherein I think some of the cannabis entrepreneurs and particularly cultivators were very worried about local control of where they could go. And there was a lot of concern that a community, this was at the time, that a community would opt in, and then the intent of the local voters would be frustrated by the local legislative body, either zoning cannabis establishments out of existence or in other ways frustrating what the voters had just done. The consequence of that is that the chapter as it now stands tightly ties the hands of municipal legislative bodies and zoning officials. It effectively says the only thing a local legislative body can do is hold a cannabis retailer with regard, I'll speak to retail because that's where the interesting problem is, hold a retailer to the same standard applicable to any other similar business, which is to say you could zone for retail, but you can't write specific cannabis rules or specific cannabis ordinances. Some of that makes sense. You don't want a state and a local body legislating on the same topic, or a state regulator and a local bodies writing parallel and inconsistent rules. Some of that, though, doesn't make sense and kind of unduly tie the hands of the local legislative bodies. Simultaneously, as a result of that debate, one thing that the cities and towns did come away with in terms of control is the ability to create a local cannabis control commission that authorizes that it must check a box before the state will license somebody. And we wind up with this paradoxical thing where that commission is created. It has this authority. It has almost nothing to do with it. But say, does this business already comply with ordinances and bylaws applicable to anybody else? That has led to a lot of frustration among local officials who took the time to build these bodies. And then they say, what are we here for? I mean, we were just asking if the person is a zoning stop law. That's the only question we've asked. So one can understand, somebody who was party to the debate that went on and understands the push-pull that led to this can understand it. But on the ground, it doesn't make a heck of a lot of sense to those folks. So that's why you see what you see in terms of concentration. The board at the end of last session, following last year's miscellaneous bill, was authorized for the first time in its history to write rules about citing. Before, it was simply an open market system. So we kind of came a little bit late to the problem. The board took action immediately to pause retail applications. It has the authority to close the windows. A problem with that is that the administrative regulations in place at the time, which are soon to be revised, promised a 30-day warning before it changed. Of course, if you have entrepreneurs waiting to get in, some people already beginning investments, they see this 30-day warning, they rush the door. And so that created a kind of long tail. Although the board acted immediately as soon as it had authority from this body to write rules, it put a pause on everything so it could. There nonetheless was a long tail and a rush in by folks. So I think a lot of people have asked, hey, why did it happen that last year there was action to kind of get a hold of this problem? Then there was a surge of retail approvals. Why did that happen? And that's basically why. There were people kind of riding that long tail in who had due process rights, who may have been millions of dollars in investment into something, who probably would have had causes of action had they not been allowed to proceed as they had expected. So that's why you see what you see. There had been a proposal in the House side for a moratorium that would simply legislate no new retail licenses for a variety of reasons that I can get into if you have detailed questions, but you'd probably rather I not for the sake of time. We don't think that's a great policy idea. We think, if you have a board, you want to protect the dynamism of the market and the competitive pressure to serve consumers and go where the market would demand. That pressure, by the way, it almost very consistently will say movement out of over-concentrated areas into underserved areas is economically rational. So in some ways, the market will favor taking care of this process if the cap is in place. But the agreement reached on the House side to
Give us the section so that we can.
to meet everybody's needs is an amendment to the rulemaking section, or the board's rulemaking authority, the same authority it got for the first time last year, which is section.
Section 4.
I'm sorry.
Okay.
But section 4 is a long one. Let me just see if I can find the page.
Ask a question about section 4.
Here we are.
Section 4, yes.
It's talking about the board. This is the locally constructed board or the cannabis control board?
When I've said board, I've been referring to the state
select
cannabis
board.
board.
Sorry, the CCB.
And in chapter 4, this is changing what that statewide board can do, not what the local boards.
That's right. These are the state boards, grants of instructions on legislative, or on rule promulgation. So if you go to page 6 of 20 of the current draft, the new change, F is what came out of F unmodified is what came out of last year's bill. The board was to write location or siting requirements that increase the geographic distribution of new cannabis retail establishments based on population market need. And that was it. The amendment that came out of the House would instruct the board now to strike the word new, so the board would look at the geographic distribution of all cannabis retail establishments, including incumbent retail establishments, in making decisions. And look at regional population. One of the criticisms of our effort to make a rule earlier was it's very municipality centric. It looked just at the municipality. People said, you know, you really need to look at regional population. And most importantly, community input as well. So this kind of set the board on a rulemaking project that we are certain will take 18 months. And so that effectively, you know, for practical purposes, sealed the moratorium because it will take us that much time. The moratorium that was being sought is no longer necessary or serves a purpose because it is virtually, there's a pause while these rules are being made and they'll take almost as long.
So there's a pause on any new retail until you establish these rules.
That's right.
So which is why we saw the rush for approvals for several new retail out of the state.
Exactly. I think some people could predict if we don't get in, you know, the next couple of weeks, the future rules will not look like.
So this is the compromise. Rules, a pause, and new rules on retail
Exactly.
based on regional population and community input.
Yes, I think there's a lot of talking with local commissions and local legislative bodies about how this is gone for them and what they'd like to see.
Okay, great. Any questions on this?
The next. The next section that I heard questions about from the initial walkthrough was section 7 around the temporary authorizations. When there's kind of an abrupt closure or disruption.
Right,
So,
for a host of reasons.
This has come up, as you can imagine, a couple of times last year, where we've seen these abrupt closures, where we've had to kind of revoke a license, then all of a sudden there's a cannabis shop that the owners are not allowed to, you know, go into or transact cannabis. How do you kind of wind down that business, pay back creditors?
Right. Sorry, before we move to section 7, I just would love to ask and clarify, because I know there are a bunch of people who've been underway in with us in email about this clause. How long do you expect the rules will take to be fashioned and passed?
My expectation is if this were to pass, this goes into effect in July. You know, this first rule has taken us now, you know, 8-10 months. You know, I imagine that this, you know, given that we now have to figure out how to incorporate local input, you know, how do we actually do locals get a veto? Do we give them a pause in order to establish ordinances? You know, I think that there's a lot more questions that we have to answer this go round. So my guess is it'll be 18 months. You know, from the effective date of the bill. You know, we're going to wait to see if this actually passes. So 18 months from July 1st.
Okay. That's just an important piece of this so that's a fairly long pause.
Yeah. And we actually are dealing with it. I mean, the problem that we have right now is if South Burlington opts in tomorrow, we'll probably see a similar rush to South Burlington amongst the just existing retailers. And so we're trying to figure out how to incorporate local input right now in our existing rules for change of location requests.
Got it.
No, I don't think so. But if it Williston, yeah, maybe.
Okay, let's pivot to section 7, sorry.
sure. So skipping to section 7, which appears on page 10 of 20 of the current draft. The new 886 is meant to give the board some regulatory flexibility to address unusual circumstances in a very broad range. There's not one particular circumstance. It's really that as the market has matured, we begin to see businesses encounter the problems that businesses inevitably do, you know, partnership breakups, marital dissolutions, bankruptcies, or what would be bankruptcies if the conventional bankruptcy system were available to cannabis establishments. Litigation, that sort of thing, or simple sudden illness of the sole proprietor. We're realizing that our current system does not give us a way to grant legal authority to the interveners that are necessary to help unwind those circumstances. Sometimes that might be a court-appointed receiver. Sometimes that might be an heir. Sometimes that might be surviving family members that aren't heirs. All kind of different circumstances could arise, but when they do on those rare occasions, it's legally important that the board be able to confer some degree of immunity and authority and basically write a special purpose permit for somebody to do things. You know, in a practical example of this is that we have proprietors in a retail store have a matrimonial breakup. They, you know, police had to intervene at one point. People were fighting over the building, and the cannabis inventory wound up in a Subaru in the parking lot. That was the best solution they could come up with. And then when the agency arranges for a lawful destination for it, the competent matrimonial attorneys, of course, say, I'm not letting my client drive that car. Nobody can drive that car. So it's simple things like that in some cases. In other cases, it's being able to cooperate with the judiciary where a court to want to appoint a receiver. One of the rules about who can operate a cannabis establishment is that nobody can be involved in more than one of the type. Of course, if you need a receiver to run a manufacturer or something, you want somebody who knows what he's doing. So everyone interferes. That's why you see the text that you do. And so it's an almost infinite range of possible reasons. It'd be very narrow. What the section tries to do is set the bounds of what one of these permits would look like so that responsible steps are taken to bound it and the board isn't just giving out a hall pass to do anything.
So that seems like a fairly straightforward need.
If I could,
Yeah, David.
Is there some similar stipulations for other sensitive industries like gun sales, ammunition sales, explosives? Those are all kind of special, or special certifications somewhat similar to this case.
Yes, honestly, I don't know that much about the law around gun sales, but I know that in high risk industries, whether it's blasting or gun sales or alcohol events, it's quite typical to give it, right permits, almost like BEC does. The permit isn't just a green light, red light. It's a set of conditions and guardrails. And that's what this would set us up to do.
So I get that. But my question is, do they have similar, what would you call this? So incapacity, special permitting. Yeah. Is it easy to transfer those kinds of lessons learned into cannabis?
In some cases, yes. In some cases, there's some disanalogy. Yeah, if were we to go write one of these, I think the first thing we do is go talk to other agencies that have done similar things that DEC is certainly one.
Well, I guess what I'm asking is, have you done that just to see if
we originally met with the Department of Financial Regulation to see the process that's set up for dissolution of a bank, financial institution. And we decided that messing around with the court process might confuse the judiciary. I talked to the court administrator's office, and I think that what's better is to allow the court process to play out how it was going to play out with the receivership. And then we just authorize that receiver, the person that the court selects, to actually be able to transact in cannabis to do their job. So that was a kind of original origin of this section. When we started noticing this problem reoccurring, it's that we just need to be able to, whoever the right person is, we need to authorize them to actually transact in cannabis.
Great, thank you. Next section. So you're pleased with the landing spot for this?
We think so, yes.
Yeah, great.
Background checking, I think, was the next question that folks had.
Yeah, and it's section 11. I don't have a list of.
There's a few.
It's scattered.
Yeah. I mean, the origin here is
because there is a thing that says background check as a
section 5.
Yeah, as a non-law enforcement.
It's here also in section. Oh yeah, section 2.
As a non-law enforcement agency, we're not allowed to, by default, receive criminal histories from the FBI, the NCIC, the National Crime and Information Center. You have to authorize us to do this. You do this with a lot of other non-law enforcement agencies. And then once we get authorized by statute, we apply to the FBI for the ability to receive criminal history records. They come, VCIC came and made sure we had double locking doors and everything that is required under the federal statutes. And then they applied for us and we got denied. And they said, essentially, cannabis is kind of against public policy. So we're going to deny you. And by the way, they started denying every state that legalized at the exact same time. Connecticut, Delaware, Rhode Island, Delaware is being held up right now because of this. So we pivoted And we asked for, or we started using kind of data brokers, the people that go through and just do a 50-state background check using public data from the courts. And so we're doing these background checks. That process is quite expensive. I mean, we pass it on to the licensees, but it's, I think, $475 for every principal or owner. And so if you have 10% or more of a cannabis license, you got to get one of these things. So we've been year after year trying to get, model our statutes on the states that have been approved. Colorado, Connecticut, et cetera.
I thought you just said they.
Connecticut has subsequently been approved. So this language is based upon their definition of kind of control or owner. And we will reapply. It's about a year-long process for them to give us the answer. But that's the hope, is that this language will actually work. I'm not hopeful, but it would be a benefit to the industry to not to pay a $35 background check fee as opposed to $475 kind of criminal history search through a private agent.
So that's what the hope is.
That's the hope.
So VCIC can't be an intermediary for you?
They can't transfer the records to us. They can get them themselves.
Because those are in Vermont. I mean, some of those.
We can get the
And they can't
VCIC.
ask for you, is what I guess what I'm.
Right, no. We can get the Vermont criminal history records. We just can't get the ones through the 50 state. It could be FBI.
And so what percent of your queries are settled by accessing Vermont data?
Well, the law requires us to do a 50 state background check.
Okay.
So we have to do the kind of private
Got it.
investigation route through the kind of public records of the judiciary.
So
Which can miss things, but like it's mostly missing like pending conviction or pending cases, arrests, stuff like that that we're not seeing through those records.
do you begin with a VCIC background check, and then if there's something there, then you would hope to be able to get it from the other 49 states?
We do the 50 state for everyone.
Okay.
Yeah.
Any questions on this? Seems worth another effort.
Right.
Because Colorado and Connecticut's having been denied. Anyone else of those states that had been denied had been approved?
Not that I'm aware of. I just say everyone's going through this right now. I think that honestly, I think it was under the Trump 1 administration, people started getting denied. Under Biden, people started getting approved. And, so I'm not
very hopeful.
Not hopeful for.
What about Massachusetts?
Massachusetts uses the same company that we do, the CSI, but I'm not sure if they're been approved for the 50 state or not.
Okay, well, ever look, we'll live in hope.
Yes.
Okay, next section.
2-year ID card and product registration.
Yes, this is an idea that came out of industry and we really agree with that.
This is section 6.
Section 12 I have, is that right?
I have cannabis establishment identification card in section 6.
No, I think that's that is the section that takes out an unnecessary temporary card provision.
Got it.
It is there. It's a simplifying measure that should make people need to interact with us less, but it's not the meat of the.
Okay, then where's the meat?
Let me see if I can do it here. This is the.
Section 12, it's page 16.
Page 16.
I guess it starts with 17. It starts on 16, the changes.
Okay, it's on its products. So you see these on a screen, but they're very hard to find on paper. I'm sorry. So turning to page 17, these are really simple nips and tucks that turn what used to be an annual process into a 2-year process for two things that were kind of burdensome to cannabis retailers in particular and manufacturers. Everybody in the system, all the employees need an employee ID card. It used to be that you had to come and get and renew that every year. Now the board would offer a 2-year employee ID card, very much like the way that you register your automobile for 1 or 2 years at your option. So for people that knew they had a long-term employee and didn't want the paperwork, they'd pay more, we would see one out of us, everybody would be happy. The second products section, which is now numbered subdivision 10, does a very similar thing for product registration. Each product that's going to be sold in the regulated adult use system has to be registered by the board. It's given a registration number, and its lab results are evaluated against certain parameters to make sure that it's fit for sale. Right now, that's an annual process, and the sense is that not every product needs to be seen again annually. And the default I've talked with folks in the industry about is going to land at 2 years. That most products don't need to be seen again every year. The reason you see somewhat more complex language here is that product characteristics differ. There are some kinds of products that are not shelf stable that long and that do need to be seen again on a more frequent basis. Or there may be some high-risk products where the board isn't comfortable clearing them on a 2-year basis. But this would give us the latitude to assign a rational time period rather than be locked into 1 year, and then within a range of like 1 to 3 years, I think is what we could expect, with the default being 2 years.
Any questions?
The last thing that I heard questions about are the new attorney position. As it stands right now, Gabe is our sole attorney for the board. We don't get the support of the AAGs. Really, the main rationale really is, we went from early on to kind of a licensing agency and kind of an education agency about our regulations. We have now kind of started to see more and more compliance actions. And I do have numbers that I can share with the committee if you'd like to see them. But we are just seeing kind of a pretty significant uptick in the complaints that we're receiving, which lead to investigations, increased investigations. And then kind of our standard process is for minor stuff, letters of warning; for more serious stuff, notices of violation. When we do those notices of violation, they include kind of a penalty, and people can appeal that decision, and they can appeal it to the board. In those appeals, Gabe kind of acts as the prosecutor, but he's also advising the board. So there's apparent, appearances of conflict there when Gabe has to kind of be both kind of objecting to things and then advising us how to rule on those objections. Really the attorney position is just going to be in charge of the kind of vertical management of compliance from kind of the initial complaint through the investigation, through the kind of prosecution. Gabe's role would be what a general counsel's role more generally is, to advise the board, to help us kind of deal with, edge advertising cases, or kind of, some of our product registrations, the types of things that he does on a day-to-day basis.
And but this all begins with a complaint. Who does the investigating?
So we have, I think, 9 compliance agents right now. So they don't always start with a complaint. I mean, sometimes they start with, we've noticed a violation when we're out investing, when we're out doing our routine compliance checks.
So there are 9 people working for you that do investigations?
I believe so. Which, we try and just maintain a general ratio that's consistent from state to state between number of licensees and compliance officers, so that they're not overwhelmed with the amount of, we have to do annual inspections on everyone, frequently more than that. So, that was kind of, the thing is we've had a moratorium right now on cultivation licenses and retail licenses. So it seems to me that ratio will be pretty stable moving forward, unless there's major changes to the market.
And you've obviously advocated for this in your budget that was in the governor's budget, or
so the
or you do your own separate budget as an
independent agency. So this was not part of the governor's recommended budget.
Right, but it's part of your budget that you've advocated
right.
for with a purpose.
Yes, and the thing is we have some we have vacancy savings because, there were delays in building our lab, with flooding and everything else. BGS was kind of focused on other projects. So those three positions that were authorized for our lab are all vacant right now. Those are budgeted for in our FY26 budget. So there's going to be vacancy savings there that we can use our kind of existing governor's recommend to pay for this position in the first year. And then, it's not a huge amount of money, but these positions, these, enforcement actions do include administrative penalties. So this position will bring in a certain amount of money every year as well.
Great. Anything else? Yeah, David.
And I believe you mentioned that, do not have access to the assistant attorney generals because you're an independent.
The attorney general,
We have a general counsel, but we don't have kind of an assistant attorney general that's embedded in our agency like all of the other agencies do.
That's because you're independent.
We're independent, yeah. They are defending the lawsuit, the advertising lawsuit for us. I mean, Gabe has been helping with that as well, but when they're defending the kind of constitutionality of the laws, they get involved when they're just dealing with our kind of day-to-day compliance issues.
So I think is that it for what you
Yes.
have at the moment? Because given everybody, you are happily local.
Yes.
Everybody else has come from afar. So I would love to shift to the people who come from afar. And I think our next person is Sam Belvins, then Jeffrey, then David. I'm not sure we're going to be able to, given the time we have, be able to have everybody, but we will be returning to this. So if there is a major time constraint, let me know, but otherwise we're going to start with Sam. David, do you have a major time constraint?
I'm here at your pleasure.
That's not the answer. Okay,
Metropolitan.
it sounds like this. Okay, Sam, welcome.
Hello, I am members of the committee. Thanks for having me here. My name is Sam Bellavance. I'm a farmer in South Hero, Vermont. I'm also on the board of the Cannabis Retailers Association of Vermont. And I think I'll just touch on some of the issues we've talked about and give my perspective here. First off, on product registration, I think there is broad alignment between industries and the board around the general consensus of moving towards a standard 2-year registration, with some products perhaps needing a 1-year, some products being available for a 3-year registration. In the current draft of language, the phrase annual registration is still in there. I think that's a little bit opposed to the intent that was just expressed by the general counsel as well as the chair. So I would like to make a small update, really reaffirming that default would be a 2-year registration, but also giving the board the authority to do a shorter or longer registration should they require that. So small update there just to reflect the intent of industry as well as the board with that language. The next issue I would like to discuss would be limited event permitting. This is some language I had sent to the committee. I can send it again if anyone hasn't seen it yet. But I do think it's very important for the growth of the cannabis industry in Vermont to open the door for some limited event permits to be issued by the Cannabis Control Board. Event permitting could be for things such as weddings. It could be for a music festival. It could be for any kind of private event that could occur, on private property in Vermont where folks may want to serve and consume cannabis. Very similar to how alcohol permitting is done in the state. And, I think it was very heartening to hear one of the members of the committee talk about are the lessons that can be learned, from alcohol. And I think there is in this case. And the language that I've put together is language that the chair is familiar with and, really is establishing a very similar permitting process to what we use in the alcohol industry.
And how did that proposal fare in the House?
It has not been introduced in the House.
Okay, so you saved the Senate.
I did save it, yes.
Saved the Senate.
Yeah,
Yes.
I know you'll all understand it when you're ready to go here, but I think it's something just to give a little perspective here. Massachusetts and New York either have some cannabis permitting or are moving forward on
Special events.
Yes. So I think that's something if we want to stay competitive from an economic standpoint, It's really essential for us right now. If I'm already married, but if I wanted to attend or host a wedding, that served cannabis instead of alcohol, let's say for religious reasons or for a personal
Baby shower.
Exactly. Gotcha. It would be easier for me to do that in Massachusetts or New York than it would to host that event on my own private property in Vermont. So that's why it's essential for us to update this language. And what I really like here, a lot of the language that's in my proposal still gives the board broad authority to figure out the details here. Because I do think there are legitimate questions. What about larger events? What about smaller events? Is it an event that's going to be visible to the public? Is it an event that's going to be not visible? Those are all things that I think can be figured out during the rulemaking process. But I think it's critical to create the broader infrastructure for
create that
permit.
opportunity.
Exactly. So
Okay.
I think that would be something that would be very helpful for Vermont, as a tourist state to open up that opportunity. I also think it's a great option for retailer businesses who are feeling, the pinch of that oversaturation in their small town. This gives them an ability to maybe diversify their business. It also gives the ability for cultivators who are maybe having a hard time getting on the shelf to another avenue to sell their products. So I really view this as a win-win proposal. It's similar to what other states are doing. And it's a topic our regulators are familiar with, and believe will be broadly supportive of. So I think I'll end it there. Those are the two things.
Those are the two big asks. And what is your retail establishment? Tell us.
Sure. My retail site, it's called Lake Effect. We're in South Hero.
That's right.
I think we are a good demonstration of, how cannabis has integrated itself into Vermont's economy. My family has a dairy farm, and then I got into hemp as part of the farm, and then cannabis cultivator. Now we're a retail store. So I think it's really something for the community to have in mind.
And have you had several special events approach you about wanting to be able to serve cannabis at them?
Yeah, we were wanting to do an event with Zero Gravity Brewery. Again, that's something that there isn't the authority to do that right now. But I think if you look at Vermont's craft beer industry, can you imagine if they couldn't do any festivals, if they couldn't cater at weddings? Think about the economic impact that would have. So I think that's something to keep in mind here. We've already seen how this works for Vermont craft breweries, and I think we should have a similar attitude towards our craft cannabis growers.
Thank you. Any questions for Sam? Tom?
I'll just say one thing. I would be open to looking at language to allow for these special events. I'm ambivalent on this topic, really. I don't like seeing 13 hot stores in downtown Burlington. I think it's an oversaturation, but I'm not opposed to allowing the special events to have that. And I like the idea of that creates somewhat of a leak valve. Maybe it's, I don't know if you can connect the two, but to diminish the desire for people to stand up more stores in these concentrated municipalities.
So good point. And the language, I believe, has been sent to Michelle. Yes?
Yep.
Yes, please. Yeah, I think we'll send it for us to consider. And I think you've seen the language, right, Gabe? And great. So we'll continue that conversation. Thank you.
Thank you. Thank you very much.
I think Jeffrey is next up.
Yep, and Graham. Yep.
Welcome. Oh, and Graham. It doesn't have Graham, but welcome both of you.
Are we? This is our last 7 minutes.
I got a sharp time.
We have a sharp noon, and I just want to ask you this favor because our schedule tomorrow is pretty full. The question I have for you is, are you willing to come in at 8:30 or 8:45 to hear from Melissa and the planner?
Should not be able. Should the board meeting.
Okay, so bag that idea. We'll figure out something else. And maybe we can do a little bit of lunchtime. What does lunchtime look like tomorrow, everybody?
No, I'm just.
So is this 2 pieces for each person? Okay, got it. Okay. So Jeffrey and Fran, welcome.
Thank you, Chair.
Guys,
Thank you,
one
Chair.
of each.
So again, just the time check, we're wrapping up the noon.
We are, we will continue this, obviously. This is just the beginning, we've just had walked through this, so this is just beginning. This will be ongoing. Apologies to everybody.
I think maybe for the record, Graham Unite Strupanot, him, rural Vermont Policy Director.
Jeffrey Tullo, thank you. Executive Director, co-founder of Vermont Growers Association.
And I think given the time, we're just gonna take a couple minutes, we can make time for at least Ornella and Jean to give a little bit to you, so we'll just, you know.
Oh, right. Now, why do I have them bracketed?
Mark Hughes was going to testify and yielded his time to LAOB. I think we should hear from them in a longer.
Yes, I do too. No,
And we can come back.
Can you come back? Okay,
Yeah,
great.
we can totally come
Because
back.
we apologize, as I said at the beginning.
We know how
our
it flows.
Funding
We're good.
priorities
Yeah.
had to be set in. Right.
Yeah, totally.
Thank you. So if we could just begin with Jeffrey, and then I think we'll ask all three of you, David, to come back. I apologize. There we are.
And can we come back to, can we come back to speak soon? I don't think we'll
Yeah, why don't you
5
start?
minutes.
Yeah, you're welcome to give you.
So I guess, so Vermont Growers Association, we formed in March of 2019. We're one of the few trade associations in the States. We represent over 80 businesses. So we're probably one of the largest nonprofit member-based organizations representing the sector. Sector is very important. We feel for Vermont, there's over 630 active licensees, significant representative that's generating over 20 million in annual state revenue. And largely responsible for upwards of 1,500 jobs. So, this is still a new sector, but we feel like it's important. And there are a lot of families and small businesses that are behind this market.
Did you say there were 80 growers?
We have over 80 members in our
organization. Members.
Yes, exactly. And though we've got growers in our name, I want to make a point that we do represent our UGA members, represent every aspect of the supply chain, whether retailers, product manufacturers, or cultivators.
Yeah.
I guess just to be brief, if I could impart anything on this committee to maybe start the conversation or continue it, that is, we're coming up on the 3-year mark. We have some moments of progress. We touched upon them economically, but really we're beginning to approach a moment where the structure of the market is going to be able to get to limit the livelihoods of the individuals that have decided to participate in this industry. So there are measures that we're going to ask that you all can take in the State House to help bring some help address some of those shortcomings of the market structure. And I'll stop there. And we hope that these issues are taken up. We passed around some of our priorities. Some of those priorities include proposed language that we around direct sales. And I'll stop there.
The direct sales and festivals.
Yeah, great.
Great. Graham.
I can respond to that. Our direct sales are for cultivators and manufacturers, not for existing retailers. We're suggesting, in fact, we don't think we can support any expanded sales to existing retailers until cultivators and manufacturers are given some actual market fairness and equity. Right now, the very producer of the product the state and retailers and wholesalers are making money off of are not allowed to sell that product themselves. From an agricultural perspective, it's fairly insulting and it's irrational. That's one of our cultivators. I'm a member of Rural Vermont. We're a 40-year-old organization. We're statewide, we're member-based, we're farmer and farmer-led and not for profit. We're one of the 3 largest member-based agricultural organizations in the state. One of the other 3 biggest is NOPA Vermont. They are also a member of our coalition. They wrote the Vermont State Agricultural Strategic Plan brief on direct sales and how necessary they are for small farmers and businesses. This market is fundamentally inequitable and it is not serving the needs of those people. We don't not support decentralized opportunities for retailers, but you're going to hear some various narratives. We heard the word saturated, and I think the reality is we have a bottlenecked market. We can talk about narratives which talk about symptoms as root cause, but the reality is when we need to focus on the real problem. We don't have an oversupply of a bottleneck with clear regulatory root causes and solutions. Opt-in is one of the main causes. You discussed that there's a minority of Vermont towns which have decided to allow retailers. That policy in and of itself is creating this issue. The other policy is not allowing for direct sales that should not be subject to opt-in rules by the cultivators and manufacturers. We have language for that. It's in here.
Great. So question for you, just because our time today is going to close. It's not going to close, period. the question I have for you, you presented these ideas to the House.
Oh,
What happened?
I have a nice, I have actually something here before that. So we understand that our recommendations are falling on the Senate's point. We understand you all have many critical issues before you on the Senate. But we also heard House government operations.
Paid for the Senate, and we're clear that.
Okay.
Stuff has been said.
I will. So the House government operations is the committee jurisdiction in the House. We heard you ask them why they hadn't addressed many of the people and questions and recommendations you're hearing from us and others. And I would like to objectively explain what happened in the House. House government operations made time to hear our testimony and the testimony of the LAOB twice, once before and once after a draft revision. That includes, I think, all member representatives or organizations. They made time to arrange a joint committee hearing to hear from cannabis stakeholders, which our organization was actually not invited to until after those slots were full. Yet many of our priorities still at the top because that's what the industry is asking for. They told us that it would not make time for other House committees to take testimony or defer to them on matters of their own expertise, such as you do with Senate Ag, Senate Health and Welfare sometimes, in order to make more time for the bill in our communities to be heard. That's under testimony. I asked that question, get it on the record. But it didn't make time to address these reports that CCB authored and last year, and that we all spent a lot of time working on in the off-season to address important questions.
We appreciate that.
Right, so the House didn't hear those reports. They didn't ask for them. They didn't bring any of the priorities from our stakeholders they heard into legislation, and they rather chose to advance aggressive policy not reflected in testimony. So to us, that's an objective telling of what happened in the House. They made time. And this is similar to what we've experienced every year. And this is where I just want to be transparent that, you know, I want to acknowledge we come in today quite frustrated with legislative progress. And I'm happy to explain some of that. I just did a little bit in terms of how the House has been acting. And I did withhold a number of private conversations, which I think could be revealed at some point to really reveal some of what we are really frustrated about with this. Our intention is to be adversarial, to hold lawmakers accountable to our members, is to connect you with the community being regulated, otherwise impacted by cannabis laws for time, and to have them connect with you. You know, as Jeffrey said, we are Nova Vermont, we are the Green Mountain Patients Alliance, we are Vermont Growers Association, we are Rural Vermont, we are the Racial Justice Alliance. We are all not-for-profit organizations. We're not advocating for our own money, for our own profits. We're advocating for your constituents, for our members. We're advocating across principles around racial equity, on economic justice, on agricultural access. And we feel like we've not been heard. We've been here since prior to market inception, arguing that these are fundamental. Most of these principles are fundamental to any market. We did not support the initial bill, S-54, without these. We encouraged people to vote against it. So that's just some background on where we are at with this. We have a number of stakeholders we'd like to bring. Past licensees are no longer in the marketplace. They can talk to you about why. Current licensees, we have retailers in support of direct sales. You hear people say that retailers are not supposed to this. We believe that the majority of do. We believe that we have an organization at the table, which has more retailers than any other organization in the state in its membership.
I'm sorry, feel unheard. Have to leave. It's okay. Glad to make some time to hear more of
So-
this. Thanks.
Thank you, Brandon. Thank you, Jeffrey.
Sure.
And thank you both. Thank you all three right behind. We are so grateful to you for coming today. And again, you know, we apologize. We will reschedule this. We'll be doing an hour of this next Wednesday. Is what our guests at the moment. We're going into our agenda planning right now. Next on the agenda is agenda planning. So thank you. We appreciate it. And I'm glad this Senate exists because you said that's the last, and it's not the last. So we will have you back. And if you would be kind enough to identify anyone additionally, when you said that the people that were not heard, we don't Senate, the one constriction we have is time.
Absolutely.
So if you would be kind enough just to give us 2 or 3 additional people that we might hear from, that would be.
In addition to ourselves again.
Yeah, I mean, you two are articulate advocates.